Lead to another delay in the trial of murder suspect Richard Allen.
Today, his attorneys signaled they want to take their defense arguments straight to the Indiana Court of Appeals. In a filing this afternoon, the defense team asked Special Judge Fran Gull to certify her recent rulings. She has determined jurors would be able to hear Allen's alleged confessions, but she rejected his lawyer's efforts to argue local members of an ancient Nordic religion murdered the teen girls as part of a ritual.
Judge Gull ruled Allen's alleged confessions were freely given and that there was no evidence presented that any other suspects committed the killings. Allen's attorneys argue if the appeals court overturns Judge Gull after a conviction, that it would make a second trial very difficult to hold.
The lawyers also argue the judge's rulings, quote, completely gutted Richard Allen's defense and were unconstitutional. The motion claims that taking Gull's rulings to the Indiana Court of Appeals could delay this trial that was going to begin next month. Jury selection was set for next month again in Fort Wayne. So we will stay on top of this story as it develops both here on air and online.
Hello, and welcome to Crime in Court. My name is Heather, and this is another update in the Delphi case. So we are seeking justice and the truth for Abby and Libby, and we are also following the case of Indiana versus Richard Allen, and whether he is the perpetrator or not, we are looking at it as he is innocent until proven guilty. So that is what we do on this channel. All right, so if I flip over here, as you can see, Allen appeals Judge Gull's decision on third-party defense is the title of this episode. So we're going to read through something called an interlocutory appeal, and this is an appeal that some attorneys can make when they are in the middle of court proceedings. So the case hasn't concluded yet. There hasn't been a conviction or an acquittal one way or another. They're still in the process of court proceedings. So this appeal is kind of like whoa, let's slow down for a second. We need the Supreme Court to see what's going on here. That's kind of what the attorneys for Richard Allen are asking for. So with that, let's get started. Please hit the like button. I would sure appreciate it. And it also helps the algorithm. All right, so the motion for court to certify court orders for interlocutory appeal pursuant to Appellant Rule 14 and request to rule expeditiously on said motion. So basically, we're filing this interlocutory appeal. We need the court to certify it. So that's another problem that we have to deal with. And we're requesting that you rule very quickly. Expedite your ruling on this, please. Don't wait until trial starts before we get a ruling from you. So what do they want? Here comes now the accused Richard Allen by and through counsel and moves this court to certify the September 4th, 2024 court order granting the state's motion that prevents the defense from presenting certain evidence, and the August 28th, 2024 order denying the defense's motion to suppress certain statements made by Richard Allen for interlocutory appeal pursuant to Indiana Rule of Appellate Procedure 14. Furthermore, the defense would request this court to rule expeditiously based upon the October 14 trial date. In support of said motion, Allen states the following. Number 1, the Indiana Supreme Court has recognized that orders in limine have historically been eligible for interlocutory review, which is she granted the state's motion in limine every single thing that they wanted. And those motions in limine are subject to interlocutory review, is what the law says. So orders in limine are eligible for discretionary interlocutory appeal. Orders in limine are eligible for appellate review under Appellate Rule 14b to the same extent and with the same prerequisites, trial court certification and Court of Appeals acceptance as any other interlocutory order. The tentative nature of orders in limine does not result in the categorical exclusion of those orders from discretionary interlocutory review, which is why our appellate courts have long reviewed orders in limine through interlocutory appeals. So, big long explanation there, but um, if something gets excluded, and yeah, there's reason. If there's reasons to review, then review will be granted, most likely, if um, the Supreme Court agrees with the defense here. All right, so number two, in the past, interlocutory appeals concerning motions in limine have also been allowed to the benefit of the prosecution. After the trial court granted the defendant's motion in limine, the state of Indiana received an order in limine preventing the prosecution from presenting certain evidence. The trial court then certified the order for interlocutory appeal, and the Court of Appeals then accepted the order for interlocutory review, ultimately reversing the trial court's ruling. So that's how it should work, or that is how it works. So basically, the um, somebody asks for the appeal, and then the court has to basically certify it, sign off on it, and then it can be reviewed. So that's the process, and that's the problem is, will Gull even certify her ruling? Which that's all they're asking is certify your own ruling. So I don't know why she wouldn't, but just be difficult, and so that she can't get it overruled. I don't know, or overturned. All right, number three, the denials of motions to suppress are also eligible for interlocutory appeal review. All right, so direct review of the denial of a motion to suppress is only proper when the defendant files an interlocutory appeal. So they're appealing it now to be on the record for an interlocutory appeal. The defense filed multiple motions to suppress certain confessions that the state things that he said that the state is calling confessions. There are times where he did confess, but in all instances he was locked up in prison, which is where convicted felons go, and put in solitary confinement and put on psychedelic drugs. So I don't know. Oops, I don't know if we trust his confessions during that time frame. And was that done intentionally to elicit said confessions, perhaps from the state? I don't know, but it is a possibility. Number four, the defense contends that the court's September 4th, 2024 order denied Richard Allen's right to present a defense in violation of the Sixth Amendment to the Constitution. I heard some argument from some YouTubers saying it's not the 16th, or not, it's not the 6th, it's the 14th. I have no idea. That's someone who deals a lot with the amendments in the constitutional law. All right, so number five, furthermore, the defense contends that the court's September 4th, 2024, it has to do with due process, anyways, the whatever this is. And I don't know if it falls under it was the argument of whether his due process rights fall under the 6th or the 14th Amendments to a fair trial. Anyways, sorry. My brain slow. All right, number five. Furthermore, the defense contends that the court's September 4th, 2024 order denied Richard Allen his constitutional rights of the following provisions of the Indiana Constitution. A. Section 12. All courts shall be open and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. There have been multiple times where I feel like the state and Judge Gull have delayed this on purpose. No proof to back that up, but I just have a feeling with how things have gone. It seems like they're almost trying to obstruct justice being done, in my opinion. B. Section 13A. In all criminal prosecutions, the accused shall have the right to a public trial by an impartial jury in the county in which the offense shall have been committed. to be heard by himself and counsel, to demand the nature and cause of the accusation against him, and to have a copy thereof, to meet the witnesses face to face, and to have compulsory process for obtaining witnesses in his favor. Section 19. In all criminal cases, whatever the jury shall have the right to determine the law and the facts. So basically, the jury has the right to determine what is fact here, not Judge Gull. Judge Gull is basically discrediting, to put it nicely. She's discredited and discounted all of the testimony. And we're going to get to the testimony for the 3-day hearing. I have the transcripts and we're going to read through them. And there is most certainly a nexus or a connection between the Odinites and the victims in this case. Not the suspect, though. So we'll get into that. But, anyways, all right. So continuing on, number 6. Furthermore, as to the alleged confessions of defendant Allen, the defense contends that the court's August 28th order denied defendant Allen his 5th, 6th, and 14th Amendment rights under the U.S. Constitution, as well as his constitutional rights under Article 1, Section 12, 13, and 4 of the Indiana Constitution. If this court has erred and the determination of the error is withheld until after judgment, then the appellate victims' families and citizens of Carroll County will suffer substantial expense and damage as follows. A. Richard Allen will suffer continued incarceration while awaiting the ruling from the Court of Appeals. B. If Richard Allen is convicted without interlocutory appeal, then he, as well as the families of the victims, would first suffer through the anticipation of a ruling from the Court of Appeals or Supreme Court on these critical issues, and then whether a reversal will result in a second lengthy trial. If the appeal is in regular course, not interlocutory, results in a reversal, then Richard Allen and the victims' families will have to endure a second lengthy trial. So this is the first stop before it goes to trial. So if we don't get it appealed and corrected now and it needs to be reversed later, we're going to have to go through a second trial. So that's just going to put more burden on everybody. C. Also, the taxpayers of Carroll County will suffer substantial cost, perhaps in the millions of dollars, between appellate costs, attorney's fees, expert costs, and costs for security in 2 different counties based upon a second trial, as well as time of all the parties involved, including the trial judge, prosecutors, defense attorneys, law enforcement, family members of the victims, and others who will all sit through a second lengthy trial. So I want to back up here and say they just recently somebody did a FOIA as to the all of the expenses that have been incurred based on this Delphi case, and so far it's been over $1 million, and half of that has just gone to the defense's uh, funds to defend him right now. So the more and more they delay it, the more and more it's going to take to more money it's going to cost to take care of him and get him ready for trial. All right. Additional costs associated with sequestering a jury during a second trial would also be significant in both expense and time. Yeah, the whole jury process and sequestering and all that again, you're going to have to do. That's going to be, since they are sequestering the jury, which is very rare that they do that, it's going to cost a lot more money than if jurors just woke up from home and came to court. So, all right, D. Moreover, the prosecution of defendant Allen has brought about worldwide attention in nearly every form of media coverage, as well as extensive coverage by various social media platforms. The disclosure of facts and information, including many facts known to the public even to this day, at the jury trial will result in the consumption of this information by these reporting sources. That's for sure. So the defense is already like, well, they're going to report on it. No matter what happens, this is going to be reported on. The dissemination of this information to the public, which will undoubtedly occur, will make it more difficult for defendant Allen to find unbiased jurors in the event of a retrial. That's for sure, too. Getting a jury together after all of this for a second trial would be difficult. All right, letter E. Defendant Allen's detention circumstances are unlike any other pretrial detainee, perhaps in the history of this state. He has been and continues to be isolated from any sense of normal contact with the outside world, with the exception of his ability to make monitored phone calls to his family. This has been the case for nearly 2 years. So he is in isolation, sees no one except maybe the guards when they take him to the bathroom and take him for a shower or whatever. 'Cause that's the only time he would leave is for the shower. Or if he has like an hour of rec time or something, usually combined. All right, so this has been the case for nearly 2 years. To the extent a retrial would occur, defendant Allen's detention circumstances would place further burdens on him and the facility in which he is housed. This workload would be compounded and would likely require months and months to organize, review, and prepare for a second trial. Hold on one second. All right, moving on. All right, so letter F, the voluminous discovery offered by the state, deposition transcripts resulting from discovery conducted by the defense, and mounting number of transcripts stemming from the pretrial hearings have resulted in a monumental amount of trial preparation for both the state and the defense. So they've been doing a lot of work on their end. G, in a second trial were if a second trial were to occur, the compounding of discovery, transcripts, and other related materials stemming from this case would place extraordinary burdens on the state, defense, the victims' families, defendant and defendant's family, not to mention the judge and court staff members in both Allen County and Carroll County. Law enforcement officers from the various investigating agencies would be required to continue to exhaust their time and resources even beyond the 7 years that has already passed since the crimes were committed. And finally, the additional expenses to be borne by the taxpayers of Carroll County would continue to mount. It is for these reasons that an interlocutory appeal addressing the issues of defendant Allen's pretrial detention and incriminating statements allegedly made by him thereafter is appropriate. So these incriminating statements that were made, potentially illegally, they were not obtained with the proper means from law enforcement. So these confessions might have been coerced. They were not voluntary. Potentially. All right, so H. Additionally, should this court not allow these issues to be heard by the Court of Appeals in an interlocutory fashion, then during the jury trial, which is set to begin October 14th, the jury would be sitting for hours or perhaps even days while the defense presents its evidence in an offer of proof. Whereas, should the Court of Appeals find that the trial court was in error, then the jury will now be forced to wait outside the courtroom or in their hotel rooms for hours or even days while the defense presents its offer of proof. The trial will run more efficiently and at less expense should these issues be resolved by the Court of Appeals before any trial takes place. 8. 8. We went from letters to numbers now. Okay. The court's August 28th, 2024 order and September 4th, 2024 order both involve substantial questions of law, and the early determination of those issues will promote a more orderly disposition of the case, to wit. The September 4th order denies Richard Allen the ability to present a defense, violating both state and federal constitutions. I agree. Number 9. On September 18th of last year, the defense filed its first Frank's notice. So we're almost a year now from the first Frank's notice. There's been 3 more since, And we still have yet to, I mean, well, now she's finally just ruled that none of that can come in, but that's only off of the motion of limine from the state. Whereas the defense has been trying to get this information, this evidence in front of the judge for a year now, and she didn't want to hear it. The state goes to what motions did they have? I don't know. They had a bunch of motions that they were arguing to during that 3-day hearing, and the motion in limine in particular, trying to not allow anything about Odinism or other suspects that law enforcement investigated, which in any other case in the world, you are allowed to look at that stuff. I mean, you should be able to impeach people on the stand with, "Hey, you told law enforcement this. Is that not true?" And things like that. So you should be able to do that. And if they can't come in and defend their client properly because she takes this ability for them to defend him away, it's going to be appealed for sure. He's going to get a new trial on that. Just on this judge alone, it has to be. She has just been so or unfair and biased the entire way. So there's got to be a way in the future, if he gets convicted, to appeal it. But this is now. We need help now. So we're asking the Supreme Court to step in and interject so that this first proceeding could be a little more fair. All right, number 9. Yeah, so we've been here for a year now talking about the Franks notice. September 18th, the defense filed the first Franks notice, at which time the defense revealed in great detail its defense that Odinism, Norse paganism explained the unusual nature of the crime scene, and furthermore identified particular suspects who were tied to the victims and/or tied to the crime scene. 10. The September 18th Franks notice was very transparent and left no doubt that the defense would be claiming that A. Odinism/Norse paganists were involved in the homicides of the victims. B. Law enforcement began investigating the links between the crime scene and Odinism/Norse paganism within 3 days of the homicides. C. That law enforcement began investigating Brad Holder and Patrick Westfall as suspects within 3 days of the homicides. I don't think that that's a coincidence that paganism or this Norse paganism and Brad Holder and Patrick Westfall were both suspects or suspected to be involved in this crime within 3 days. D. That at least 3 law enforcement officers continue to investigate into the Odinist Norse paganist ties to the homicides, and particularly ties between Brad Holder, Patrick Westfall, and certain men in Rushville, Indiana, to the homicides. E. That Richard Allen had no connection to Odinism/Norse paganism and therefore could not have left signatures of Norse paganism at the crime scene. 11. In spite of the prosecutor knowing defendant Allen's third-party defense on September 18, 2023, the prosecution waited over 7 months before filing its motion in limine on April 29th of this year. The prosecution's motion was filed 15 days from the May 14th trial setting. 15 days from the May 14th trial setting. He's trying to get rid of squash their defense altogether. On April 29th, the prosecution filed its motion in limine requesting in paragraph 7A and 7B that the court prevent the defense from presenting evidence that explains the defense's belief of what the crime scene shows, i.e., that certain signatures the KILLers left at the crime scene revealed that a ritualistic KILLing occurred at the hand of Norse paganists or Odinists. Because Richard Allen has no ties to Norse paganism nor Odinism, the evidence the state of Indiana sought excluded would prevent Richard Allen from arguing that Richard Allen did not commit the crimes, as he knows nothing about Norse paganism and therefore would have no motive nor knowledge to leave signatures of Norse paganism behind. So he has no knowledge of it, so why would he have left runes behind or whatever you want to call them? All right, so on August 1st, 2024, the defense presented evidence through expert witness Dawn Perlmutter that the crime scene was a quote unquote textbook ritualistic KI double Ling. This opinion was offered for an expert who literally wrote the book on analyzing a crime scene for a ritualistic homicide and also has taught FBI and other law enforcement agencies all over the country what a ritualistic crime scene looks like. Furthermore, Dr. Perlmutter has almost exclusively worked for law enforcement and prosecution, not the defense. So Dr. Perlmutter testified for the defense, which says something because she usually doesn't. The jury would be able to assess the weight to give Dr. Perlmutter's assessment of the crime scene. Exactly. This is a jury decision. The jury gets to decide, was it a ritualistic KI double Ling or was it Richard Allen and he tried to cover it up and make it look like that? Or whatever. Or they don't even know that the runes and they don't even see because the state somehow keeps it out. I don't know. And they don't even know all the truth. They don't know about the runes. What if the jury never finds out about that? This makes me so angry that she can obstruct justice like this. I think she should be put in prison, Judge Gull, for trying to take away this man's rights completely. All right, so number 12. Furthermore, in its April 29th, 2024 motion in limine, paragraph 7C, 7D, E, F, G, and H, the prosecution requested the court to prevent the defense from presenting evidence that tied alternative suspects involved in Norse paganism, Odinism, to the homicides, including evidence of the investigative efforts of three very, very credible law enforcement officers who had no ties to one another. Um, but these three, believed that the evidence credibly pointed the finger at certain third party suspects and also social media posts that provide a nexus between the certain third party suspect and the homicides. And the victims, one of the victims was dating the son of one of the suspects that we're not allowed to bring up, apparently. It makes no gosh darn sense to me, her ruling in this. All right, number 13. Furthermore, in its April 29th, 2024 motion in limine, paragraphs 7I and J, the prosecution requested the court to prevent the defense from presenting evidence that third party suspects Keegan Kline and Tony Kline committed the homicides, even though credible evidence existed that A. Keegan Kline had arranged to meet one of the victims on the day of the homicides. So that is irrefutable evidence that the state wants to not let the jury know. B, that Keegan Kline implicated his father, Tony Kline, as being involved in the homicides. And C, that law enforcement tried to tie Richard Allen to Tony Kline and arguably only interrogated Richard Allen because of law enforcement's initial belief that Tony Kline and Richard Allen knew each other and committed the crimes together. This is like bombshell. What? We didn't know this. This is all new information. Law enforcement, I'm going to read that all again, and then we're going to talk about it. So, law enforcement tried to tie Richard Allen to Tony Kline. So, remember, we've got, you know what? Hold on. Let me grab my PowerPoint. Perfect. So, here, I've got this is the connection. So, I've gone through, I went and did a who's who of Delphi. If you guys are interested, I did a PowerPoint and I go through all of the different suspects and who they are in the sketches, and we go over all of this. But in the end, here is the connection. So we've got the Delphi Vinlander crew, who consists of Patrick Westphal, Brad Holder, Johnny Messer, who is the recruiter for the Delphi Vinlander crew. There's a bunch of people from Rushville who are the Vinlander recruits, I'm calling them, because this is Elvis Fields, Rod Abrams, and Ned Smith, and they all were trying to join this Delphi crew. They were from Rushville, but they were trying to join this Delphi crew. So as you can see here, so those are the Vinlanders. Those are the Odinists that are suspected to be involved, allegedly. And as you can see, Brad Holder has a son named Logan who was dating Abby. And Libby was best friends with Abby. So therefore, they were out together. But we were talking about Keegan Klein. So let me go back to him where we had, so Keegan Klein here, he admitted to creating a fake Anthony Shots profile. These were the catfishing accounts. This is what Keegan Klein looks like, and this is what he portrayed himself to be. Just saying. So he did this to communicate with underage girls with the expectation of receiving pictures from them. Like he wanted to exchange pictures. Questions about incident. He was questioned about an incident involving a young girl giving Anthony Shots her address. This would happen like just a few weeks after the abduction and homicides of Abby and Libby. He was giving away his address to her. Oh, this young girl gave her address to Anthony Shots profile. Sorry. Okay, so the young girl, underage girl, gave her address to Anthony Shots. All right. He was told that someone he was supposed to meet. He told someone that he was supposed to meet up with Libby, but she never showed up that day. So that's what he told a friend. He also communicated with Libby via social media. One of her last contacts was with Keegan Klein. So, how can you say you can't bring in Keegan Klein when he is literally part of the investigation? Because she was communicating with him that day. How does that not come up? That is so prejudicial towards Richard Allen by not letting this come in. Also, he faces 30 years of child rhymes with corn and exploitation. So he's already behind bars. He also has a father named Jerry Anthony Klein who had a criminal past with convictions of harassment, battery, and theft. He made repeated illicit calls to women with of the adult nature. And he also lived with Keegan at the time of the abductions and homicides, and he may have used his accounts, he may have used his son's accounts to talk to underage girls. So there's that. I don't know. He has a criminal history, but I don't know if he's like in and out of prison or he's out now. I'm assuming, but his son is not. So I don't know if nothing was ever found proving his communications with underage women, girls. Sorry. So yeah, so there's that. So I wanted to give you that brief overview just in case. So the defense is not allowed to talk about Tony Klein. And this is all new information here that we're finding out. Law enforcement tried to tie Richard Allen to Tony Klein and arguably only interrogated Richard Allen because of law enforcement's initial belief that Tony Klein and Richard Allen knew each other and committed the crimes together. Initial belief. By saying this, law enforcement's initial belief makes me believe that they are not associates, they do not know one another, and they did not commit this crime together. Letter D. Law enforcement officials discovered a cache of child rhymes with corn at Keegan Klein's personal cell uh, during the course of their investigation. So again, like how can you not talk about another suspect that was in communication with one of the girls that day? E. Law enforcement officials. Let me slow down, Heather. Law enforcement officials actually transported Keegan Klein to an area near the crime scene to corroborate his version of what he and his father Tony did near the crime scene on the day in question. So he was even brought there to be questioned more about what he knew. He was brought to the scene. And we're not going to talk about that. It doesn't come up in trial. 14. Furthermore, in its April 29th, 2024 motion in limine paragraph 7K, the prosecution requested the court to prevent the defense from presenting evidence of third-party suspect Ron Logan, even though credible evidence existed that A, the bodies were found on Ron Logan's property, B, an FBI authored probable cause affidavit stated that Ron Logan I placed a phone call on or around his property around 2:09 p.m. using cell tower data, and I guess that's true. That one, he did that, and two, Ron Logan provided false information about his activities during the time. So he gave false alibi. He gave false information about his activities during the times the crimes were committed and employed others to assist in deceiving law enforcement, and furthermore plotted an alibi for a crime that had not yet been discovered. That makes no sense to me. That makes me believe Ron Logan may have had something to do with it. Where's Ron? I've got Ron on here too. Here's Ron Logan. He owned the property on which the girls were found. They were found about 1,400 feet away from his home. He was investigated by police early on. He allegedly asked family to lie about his whereabouts. So we just read in the court filing that he did that. His phone puts him near Monon High Bridge, but he told others that his alibi was something else. And his ex-girlfriend even suspected that he might be involved. And he actually walked with a limp, and he could possibly have been Bridge Guy. He is deceased at this time. So if he did have any involvement, we do not know. But I wonder if he was an Odinist. I wonder if there's any ties to him being an Odinist and being involved with these crimes. But I don't know if there's any connection to him and all these other Odinists. That would be something to learn. I don't know. So, anyways, hope my visual aids help there. All right. And 3, a court found that said probable cause affidavit provided probable cause that evidence of the homicides would be found on Logan's property. So the probable cause affidavit stated that the homicide was on his property. So I don't know. I don't know how you keep that out. How you avoid. I know how you avoid it if you're the state. You don't want it to come in, but I don't know how legally, constitutionally, you can prevent him from defending himself. I just don't get it. All right, 15. Furthermore, in its April 29th, 2024 motion in limine, paragraph 8, the prosecution requested the court to prevent the defense from presenting evidence from law enforcement officer Todd Click, who investigated the Norse paganist Odinist ties to the homicides, as well as the ties of certain third-party suspects to the crimes, primarily those identified in paragraphs 7A through H. So the Vinlander crews, these guys. What else was I going to show you? I don't remember. There was something. Oh, Todd Click. I was going to show you the investigators while we're at it. So, nope. Here. I just passed it. All right. So Todd Click, as you can see, he's right on your left. He is a detective for Rushville, Indiana Police. Greg Ferenczi. These are the 3 cops that were that had been investigating the Odinist angle. So Todd Click, Greg Ferenczi, who is deceased, he was a detective for Terre Haute Police, and he was an FBI task force officer. And then we also have Kevin Murphy, who is a detective with the Indiana State Police. So Indiana State Police, Terre Haute Police, and Rushville, Indiana Police. 3 separate police agencies. It's not just 3 different police officers that were doing this and investigating this angle. It's 3 separate agencies. Like, they're not even connected with one another, these 3 guys. And yet somehow they are onto this Odinist connection. So these guys, three reputable, I can count, three reputable, honest cops that were looking into this Odinist angle. We also have, if you count Richard Allen's attorney, his three attorneys now, and the two that he had, the other two public defenders that were assigned to him when Judge Gull kicked his current attorneys off. So that's five reputable defense attorneys and three cops looking at this Odinist angle. I mean, and we have experts that are also testifying that there is an Odinist tie. So how can you say that there's no evidence? I just don't get it. I just don't get it. All right. Anyways, sorry. So Officer Todd Click, who investigated these ties, and he also identified Todd Click wrote a report, so he would be the likely one to have him come and testify. Click's testimony would provide evidence that connects those third-party suspects to the crimes, that nexus that Judge Gull says doesn't exist. But Todd Click can connect the third-party suspects to the crimes, as would the testimony of law enforcement Kevin Murphy, who was assigned said connections alongside Click, um, including testimony that Elvis Fields posed the question to him as if Elvis's spit would be found on one of the girls, but he could explain it. Would he, Elvis, be in trouble? So we know that Elvis was talking to Kevin Murphy, and Kevin Murphy was dropping him back off at home, and all of a sudden Elvis Fields turns around and he's like, "Hey, if my spit was found on those girls and I could explain it away, would I be in trouble?" And yeah, what kind of question is that? Very odd. Furthermore, Murphy would be able to tie Elvis Fields from Rushville, Indiana to Brad Holder of Logansport, Indiana, and that Brad Holder was an active Odinist whose son, Logan Holder, dated one of the victims and who also has changed his story multiple times about whether he had ever met the victim, and whose social media posts included evidence that tied Holder to the crime scene. Remember, Holder posted some graphic images that looked similar to what the crime scene may have been staged as, with the runes and whatnot. So very soon after, he posted some things like that, and then Elvis Fields copied him, and they would post similar photos back and forth with one another. All right, furthermore, in its April 29th motion in limine paragraph 9, the prosecution requested the court to prevent the defense from presenting evidence of geofencing, even though that geofencing evidence provided evidence that other third-party suspects were in the area of the crime scene at the time the prosecution is claiming that the crimes were committed. So this is highly unusual, too, that she is blocking them from using geofencing data, because it's a state's tool. It's a tool that the state uses to find who is in an area at a specific time, whose cell phones, I should say, whose cell phones are in a specific radius at a specific time. And that geofencing data shows that there were other individuals in that area where the girls were found the next day. So either those people walked past the area and didn't see bodies, so that means that Abby and Libby weren't there at that time when the state is claiming that they were eventually, that their lives were taken. I think they were abducted. That's why I keep saying abducted. I think they were abducted, held somewhere, and then brought back to that spot for a ritualistic something or other. That's my opinion. But you guys can come up with your own opinions based on the evidence. That's why I just read through court documents and try to analyze what I'm reading, and that's all. So you guys do the same, and don't take my word for it either. Do your own research and look up your own things, is I like to do, because it helps give you multiple perspectives. All right, so number 17, after the May 13th, 2024 trial date was continued, The court held the hearing for said motion in limine on August 1st, and likely because of the voluminous amount of evidence it received and reviewed, the court was unable to rule on the state's motion in limine until September 4th, which was 40 days before the scheduled October 14th trial date. So their motion in limine hearing ended, they had a 3-day hearing. It ended August 1st, and we don't get a ruling until September 4th. So that whole time, as she's reviewing all that stuff, supposedly, um, she waits until 40 days to get out her ruling. Included in the court's ruling was the court's belief that the admission of the evidence would confuse the jury. Isn't that isn't that the point of a defense attorney, is to plant the seeds of probable doubt in the minds of the jurors? So i- if they are given evidence that might contradict the state's theory, that doesn't necessarily mean it's there to confuse them. It might mean that the state's wrong, but that's not how they're seeing it, I guess. The defense respectfully rejects that premise. Evidence that the court excluded from the jury would actually provide the jury an understanding explanation of why the crime scene appeared the way it appeared. Exactly. The more information they have, the more educated they are to make a decision. In fact, the defense would argue that by keeping the evidence of Norse paganism from the jury, it would be confused as to why the crime scene appeared the way it appeared. Additionally, the inclusion of evidence of third party suspects as being connected to the homicides is not confusing, but rather easy to understand, and that it is up to the jury to either accept or reject the defense's contentions that the evidence connects Norse paganism/Odinism and third party suspects to the crime. Agreed. This is not a Gull decision. Gull doesn't get to make this decision and say that's not a fact without, I mean, really, she has had so much proof and so much evidence connecting the dots for her, and she's still just blind. All right, 19, willfully or ignorantly. Number 19, essentially, with its September 4th order, therefore 40 days before the trial is scheduled to begin, Richard Allen's defense was completely gutted. Yes, you took away every single bit of his defense because the state knew what the defense's arguments were going to be. This is why it's dangerous to put your arguments out before your trial starts. But sometimes it's a strategic decision, especially when your client is sitting there and being tortured in prison. Prison. He hasn't been convicted yet. He should be sitting in a county jail, not a state prison for convicted felons and being given shots of hell at all to make him hallucinate. All right, number 20. Certainly, between the Franks notices that have been filed and were made part of the record and the exhibits that were attached to those filings, as well as the evidence and testimony this court received during the July 30th through August 1st hearings, the Court of Appeals would have more than enough record to review to either support or negate the court's September 4th, August/September 4th order. They wrote August and meant September. Um, what was I going to say? Yeah, so luckily and recently we just got the transcripts. So from that hearing, and they had ordered them too from the court. So we got a notice a while back that they had ordered the transcripts from the court. So they have the transcripts of the 3-day hearing, which we have experts on the stand for the defense arguing the Odinist theory and things of that nature. All right, number 21. The issues to be. Did I skip? I thought I did that one. Okay. Yeah. So, the issues to be presented to the Court of Appeals for interlocutory appeal concerning paragraphs 7, 8, and 9 of the state of Indiana's April 29th motion in limine would all involve whether the trial court was correct in granting the state's motion in limine, thereby denying the defense the ability to present evidence. A. Concerning its interpretation of the crime scene and how said interpretation excludes Richard Allen as a suspect. B. Concerning whether a nexus existed between certain third party suspects and the crimes. And C. Whether evidence presented warranted the court from excluding geofencing evidence. The August 28th order denying defendant Allen's request to suppress incriminating statements violates Allen's state and federal constitutional rights. On November 3rd, 2022, Judge Benjamin Diener issued a safekeeping order. So remember, he was the original judge who then just recused himself for no reason, and now we are stuck with Gull. So why he recused himself, really love to know. Anyways, he issued a safekeeping order which resulted in defendant Allen's immediate transfer to a maximum security IDOC confinement facility wherein he was detained in solitary confinement for a period of nearly 13 months. That, my friends, is torture. He was also taken without an attorney present or even representing him, which is, I'm sure, a violation of his constitutional rights. Defendant Allen was not afforded a due process hearing regarding his detention until June of 2023, nearly 8 months after he was locked away in solitary confinement. Throughout the course of defendant Allen's detention, the state of Indiana began offering up discovery in the form of incriminating statements made by defendant Allen to prison guards, inmate companions, the warden, the defendant Allen's treating psychologist, and defendant Allen's family members. So all of these people apparently say that they heard confessions or incriminating statements. Remember, this is when he was being given drugs that affect his psyche, his psychosis, and also he's in solitary, which no one should be in solitary more than 30 days. It does I think like 14 days is probably more than you need. Um, just doing that, it does wonders on your psyche as to really messing you up. But on top of that, they're giving him Helidol, orally and injections. So the times that he's making these incriminating statements, you have to remember what his circumstances are. And this is also where the guards with the odinous patches were and weren't letting him talk to his lawyers privately and, yeah, potentially, allegedly threatening him to confess. All right, 24. Defendant Allen then moved to suppress the admissibility of said statements on the basis that said statements were involuntarily made and thus obtained in violation of Defendant Allen's 5th, 6th, and 14th Amendment rights under the U.S. Constitution. Defendant Allen also asserted that his rights under the Indiana Constitution, Articles 1, Sections 12, 13, 14, were violated. On August 28th, this honorable court issued the amended order or judgment of the court denying defendant Allen's request for suppression and holding in totality that the statements given by the defendant to the various individuals were not coerced, were voluntary, and were not the result of interrogation by the state or its actors, nor the product of his confinement. Because again, Judge Gull is ruling on things that really should be determined by the jury and not her. With regard to the August 28th amended order, the issues to be addressed are as follows. A. Was Richard Allen denied his right to due process under both the state and federal constitutions while he was detained in solitary confinement without having been afforded a timely hearing on the state's motion for safekeeping order? B. Did the effects of defendant Allen's extended solitary confinement render statements made by him to the prison guards, inmate companions, the warden, defendant Allen's treating psychologist, and defendant Allen's family members involuntary and therefore inadmissible at trial. C. Were the statements allegedly given by defendant Allen to his treating psychologist, Dr. Monica Walla, privileged pursuant to IC 344631? So those are some issues that the Supreme Court would need to answer in regards to, or at least, yeah, I think that they would need to answer these in their order. All right, so the August 28th, 2024 order involves a substantial question of law that could be resolved on appeal and lead to a more orderly disposition of the case. Defendant Allen's incriminating statements stemmed from a most unique detention circumstance. Allen nor his counsel were given no choice in the matter. The issue of first impression here is whether or not defendant Allen's due process rights were violated, i.e., does the safekeeping statute require the court to conduct a hearing to address the propriety of defendant's pretrial detention circumstances? Defendant Allen is aware of any rulings in this state addressing the very issue. If the Court of Appeals were to find in defendant Allen's favor, the admissibility of statements and other evidence stemming from defendant Allen's wrongful detention would be inadmissible. The normal remedy of a direct appeal is not adequate. So, going through the process of trial, this is important for them to prove that going through the process and trial and then appealing wouldn't be an adequate remedy. We need something now. This is more of an emergency kind of appeal type of dealio because that's what it is. 27. The remedy of an appeal is otherwise inadequate for all the reasons stated herein. 28. Because of the pending trial date, the defense would further request that the court issues its ruling on this motion as expeditiously. How do you say that? It's like on the tip of my tongue and I can't pronounce it. Hold on. Oh well, I don't know where I left my phone. I was gonna make it pronounce it. I think it's expeditiously as possible. It's a big word. Number 29, obviously make it as fast as possible. Thanks, Judge, since you like to wait a month or more to rule on things. 29. The state of Indiana has been contacted and objects to the request, but waives the 15 days to respond, as they have indicated that the prosecution will promptly file their objection. So, Nick McClellan obviously objects to an interlocutory appeal, but he waives the 15 days to respond. Okay. So 30, based upon the pending trial date, the defense would respectfully request that this court rule on this matter as expeditiously, yeah, as it can, and believes the prosecution would also benefit from an expeditious ruling. It's like one of those words that it's like you see it, you know it, but it's not forming in your mind at the moment. To me, that's what is happening. Anyways, all right. 31. This motion is not made to unnecessarily delay the trial, but out of a sincere belief that the court's ruling is erroneous or erroneous. Wait, what? I think they mean is that the ruling is erroneous and will result in an unnecessary second trial should Richard Allen be found guilty. Wherefore, Richard Allen, by and through counsel, would request this court to certify the issues presented herein for interlocutory appeal and be heard by the Indiana Court of Appeals. So there you have it. For all these reasons and probably more, hopefully the Supreme Court or the Indiana Court of Appeals should take this up if Judge Gull certifies it. That's the only thing. So there's a couple obstacles in the way to get the defense back on track to be able to be able to even have a chance to defend themselves, because without being able to talk about onanism and the other suspects, He's completely handicapped. Uh, In the way that they said it, it completely gutted the defense. Her ruling in one fell swoop just went, you can't defend yourselves anymore. You've got nothing. Everything you've been working on this whole time, gone. Can you imagine that? It's her. It is her that is wasting the taxpayers' money. It is her that is blocking justice from being done. If the Supreme Court of Indiana can't see that by now, I just don't think that they're ever going to. Hopefully, this Indiana Court of Appeals is different and they have different standards and different protocols and they can get rid of her for these reasons. I don't know. I don't know if you can get rid of her, but you can certainly get them to overpeel or overturn. Why are words not forming in my mouth right now? Get them to overturn Judge Gull's ruling and then therefore give him a defense at trial. That is basically what they are trying to do. And I don't know, they have some hurdles before that can be done. So I wish all of them the best of luck and hope that Judge Gull just has a brainstorm one day a, um, and just says like, "Hey, I'm gonna take myself off this case." But she's not gonna do that, especially with trial so close. But we've all wanted her to go. They've already asked for her to be recused twice. They asked the Supreme Court to take her off. Like, what more can they do? It's so frustrating, and I just want to hit my head against the wall on this about this case because like they just keep reaching roadblocks with this stupid judge. And we're gonna go through, like I said, I have the transcripts for all 3 days of that 3-day hearing, and I'm working on recording those, and I'm gonna get them out to you guys as soon as I can. They're longer, so I don't know. We'll get through them as I get through them. So hopefully I can get them. My goal is to get them out like um, one right after another. So, like, you don't have to wait for the next one. So, we'll see. I hope I can get them to you guys shortly. So, thank you so much for watching. I appreciate you guys. Let me know what you think about the defense and Judge Gull and their non-ability right now to defend themselves. And I will see you guys in the next one. Take care. Thank you so much. Bye, guys.